How do we deal with the uncertainty of the future of COVID? A traditional pure lump sum contract may be too much risk for both owners and contractors. In other words, if a contractor would say, well, if you're going to make me assume the risk of COVID, I'm going to have to build such a large contingency into my price to protect myself from that risk that now the cost of the project is beyond what the owner ever envisioned. On the other hand, if the owner agrees to assume all of that risk, that may expose the owner to additional costs that they simply could not incur based on financing that they may get for the project that they're contemplating. The first is a lump sum contract, but with unique provisions. You could agree to exclude COVID costs in their entirety and pay those costs as a change order. That would result in the lowest contract cost for the owner, but also exposes the owner to potentially large change order requests. Another option would be to include current COVID costs in the contract, that the contractor would assume responsibility for paying those costs as part of their lump sum bid, and then any new requirements. If things get worse in the future and there are new requirements that are imposed by regulatory agencies, then the contractor would be entitled to a change order to compensate them for those additional costs. One of the owner's concerns under this scenario would be a deduct change order. If a contractor includes costs associated with complying with COVID regulations and those requirements are eliminated, is the contractor then going to get a windfall by having costs built into their price? Which brings us to another option that may be most equitable and most fair to both the contractor and the owner, and that would be the inclusion of an allowance. We frequently see the use of allowances to deal with rock excavation, where there may be an allowance included in the contract for the contractor to remove X amount of rock. And then if that X amount varies by 10 or 20% more than that, or 10 or 20% less than that, there would be a reopener to that allowance. And the contractor would either be entitled to additional compensation if they have to excavate more rock, or they would have to provide the owner with a credit if they had to excavate less rock. Certainly, you could set up a contractual situation where you could handle COVID compliance requirements the same way. In other words, build in an allowance based on an expectation that the contractor is going to incur X amount of money in complying with COVID regulations. If the contractor incurs a certain percent more than that, they would be entitled to additional compensation. And conversely, if things change for the better and the contractor incurs less than that, then the owner would be entitled to a credit. In an entirely different contractual scenario would be to have a contract based on cost plus a fee. Under this scenario, the contractor essentially maintains an open book in terms of all of the costs that they are incurring to complete the owner's project, and the owner agrees to pay those costs plus a fee to the contractor, which covers their overhead and profit. Under a cost plus a fee contract, what is typically seen for the owner's protection is what's referred to as guaranteed maximum price. This provides the owner with some certainty that the cost associated with the project will not go beyond that guaranteed maximum price. If you are considering a cost plus a fee with a GMP, we would recommend that you consider a shared savings clause. A shared savings clause rewards the contractor for controlling costs by establishing that the contractor will be paid a percentage of the difference between the actual cost and the guaranteed maximum price. If a contractor can come up with a cost-effective way to manage those costs, they would be incentivized to do so, knowing that if they can keep those total costs down, they will have an opportunity to share in the savings that would be much greater than the fee, the percentage fee that they would receive under a cost plus a fee scenario. Some parties have considered simply moving forward with the historic contract language and viewing COVID as a force majeure event. There is an argument to be made that if you're entering into a contract from this point forward, COVID may not be a force majeure event anymore. Remember the definition of force majeure. It is an unexpected event, an unforeseeable circumstance that delays or prevents performance or completion of a contract. It would be very difficult for anyone to argue that COVID is unforeseeable for contracts entered into now and in the future. COVID could be viewed as a force majeure event. So I would not rely on that if you are either a contractor or an owner, as using that clause to appropriately allocate risk associated with COVID. I also think that both owners and contractors need to take a very close look at the termination for convenience clauses that are set forth in their contracts and the remedies related thereto. The termination for convenience clause means that an owner can terminate a contract for any reason whatsoever. The contractor does not have had to have done anything wrong or have breached the contract. The owner could just decide they don't want to move forward with the project. If an owner enters into a project in early 2021 and suddenly COVID becomes much worse and the costs are going to escalate exponentially, an owner may decide to terminate the contractor for clause and put that construction project on the shelf until the COVID situation is brought under control. The question then becomes, what are the contractor's remedies in the event of termination for convenience? Prior to 2017, the AIA documents indicated that in the event a contractor was terminated for convenience, the contractor would be entitled to lost profit on work not performed. So under that scenario, if an owner canceled a project at its inception, the contractor would still be entitled to all of the profit that they had planned on earning on that particular project. Obviously, that would not be a situation that an owner would be comfortable with. And that's part of the reason why the 2017 version of the AIA documents left that clause blank and allowed the parties to negotiate what remedy would be available to the contractor in the event of a termination for convenience. Some of the options there would be just a fixed fee for what the contractor would be entitled to, or a percentage of costs so that the contractor does receive some anticipated profit, but not all of it. We encourage both owners and contractors to take a hard look at their price escalation provisions in their contracts, given supply chain issues that the industry is dealing with right now. And we've seen a lot of problems, particularly with respect to imported construction goods, where the cost may have either escalated exponentially or there could be significant delays. Give some thought and communicate about those issues at the time of contracting so that you're attempting to minimize those risks at the time of contract formation. Next, I would remind everyone that COVID is very unpredictable and fluid. We are not talking about a static risk here. So you need to allocate those contractual risks accordingly. So you need to address that unpredictability, both from a scheduling standpoint and from a cost standpoint. One of the options that we have encouraged our owner clients to consider is phasing a project. If you know that you want to get going on a project in 2021, but the uncertainty of COVID makes it very difficult for you to determine what your costs are going to be, you could consider performing the site work as a separate contract. You're not going to have as many problems with potential stacking of trades and with PPP issues as you will when you start getting multiple workers working on the interior of a building project. You could consider breaking that site work out as a separate contract, either potentially including structural steel or even doing structural steel as a separate contract, and bid the remainder of the project down the road when hopefully we have more clarity. It is very important for owners and contractors to establish a baseline set of COVID conditions. In other words, at the start of the project, are the parties agreeing that the contractor will be required to meet all of the obligations that currently exist, or is the owner going to provide some of those? Would the owner be providing wash stations? If you're using a multi-prime type scenario, it may be more cost effective for the owner to address a number of the costs that need to be incurred. I also think it is worth noting that contractors are not going to passively accept large unexpected risks. As you're drafting your contracts and negotiating, it's important to keep that in mind. Focus on placing risks with the party that is in the best position to control and mitigate those risks, while also accepting risks that you are in the best position to control and mitigate. If you get in a situation where all of the risk is on the contractor and things go south, the owner is basically guaranteed to be looking at a claim situation where the contractor is going to be looking for additional time and money to complete that project.